technology problems resolved, and this case is being live streamed on the court's YouTube channel in order to comply with Office of Court Administration directives or guidance. That provides when we're doing hearings by remote video technology that we must provide access for the public to attend court. And so we have done so by now live streaming this proceeding on the court's YouTube channel. There will possibly, there is a feedback difficulty, which we just corrected. And we will proceed. This matter being conducted by the Zoom remote video technology protocol and being live streamed on the court's YouTube channel causes the court to issue this order. The court expressly prohibits anyone from recording this proceeding by any means whatsoever, electronic or otherwise, except for the official court reporter. And Mr. Hanshu is with us on the Zoom protocol for the purpose of serving as the official court reporter, and he is transcribing these proceedings just as he would if we were doing this in person. With those pronouncements out of the way, for purposes of the hearing, with the understandings I have announced, what says the state?
State's ready, Your Honor.
And defense?
We're ready, Your Honor.
Ms. Jackson, are you, for the record, are you Winona Rochelle Jackson?
Yes.
Ms. Jackson, an indictment has been returned into this court charging you with a third-degree felony offense of assault of a public servant. You have the right to have someone read this indictment out loud to you. Do you wish to have someone read the indictment out loud to you?
No, sir.
Is that because you understand that the indictment charges you with the third-degree felony offense of assault of a public servant?
Yes, sir.
Understanding this charge, to this charge, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it used against you or held against you in any way just because you exercise your right. Do you understand that?
Yes, sir.
Pardon me, I'm having some more technical problems. Let me go on. All right, Ms. Jackson, there are some other rights and admonitions I need to discuss with you, or some other rights I need to talk to you about. For instance, I need to tell you, and I do now tell you, that you have the right to have a minimum of 10 days notice of the charges pending against you in the indictment. I'm looking at your docket entries in our court, and that helps me recall on my own that you have been in this court with knowledge of the charges since May of this year, so you've had more than 10 days notice. Nevertheless, I will grant to you some additional time to prepare if you need to have it. You also have the right to have a jury hear your case, and that's true even if you enter a plea of guilty, as you just indicated you wish to do. Do you understand that you have the right to have a jury hear your case?
Yes, sir.
I have a document in front of me entitled Waiver of Defendant that says you're giving up the opportunity to have more time to prepare, and you're giving up the right to have a jury trial. Did you sign that document?
Yes, sir.
Mr. Green, your signature is also on this document. Is that evidencing that you're joining your client in these waivers?
Yes, Your Honor.
And Mr. Smith, your signature is likewise on the document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, Ms. Jackson, I announce that I will accept these waivers and we will proceed. And then there are additional rights and admonitions that I need to discuss with you. Let me start by discussing and telling you of the range of penalties you face for a third-degree felony. A third-degree felony penalty range runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the Institutional Division. It also carries the possibility that a fine can be imposed in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face if you were to be convicted of this charge?
Yes, sir.
Then let me mention next that as maybe I didn't mention this earlier, I am aware that a plea agreement exists in your case. So let me tell you that I do not have to follow the plea agreement, but I do have to tell you if I'm not going to follow the plea agreement. If I do not follow the plea agreement, I will tell you that. And if that occurs, you will have the absolute right to withdraw your plea of guilty. And if so, we just start all over. Restated, if I don't follow your plea agreement, you can take back your plea of guilty. The other side of that coin is this. If I do follow your plea agreement, then you will be bound by the terms of the plea agreement. You will not be able to get out of the terms of the plea agreement if I follow them just because you later change your mind. You can't even get out of the plea agreement terms by appealing your case. Now, that's different than the usual rule, which says that you have the right to appeal even from a plea agreement. It is a limited right, but it exists nevertheless. But there is an exception. The exception says if a part of your plea agreement says you give up the right to appeal as a part of that agreement, it means what it says, and you cannot appeal. Your plea agreement has that provision marked as a part of the plea agreement. So if I follow your plea agreement, you cannot appeal at all. Do you understand that?
Yes, sir.
Then let's go further in this plea discussion. And let me ask you some questions I'm required by statute to ask. First, are you a citizen of the United States of America?
Yes.
Where were you born?
Abilene, Texas.
Next, I ask, do you consider yourself presently to be mentally competent?
Yes.
Do you understand what's going on in this proceeding?
Yes, sir.
Have you been able to understand the charges against you so you could discuss those charges with your attorney, as well as the facts that surround the charges, and assist and cooperate with him in preparing to meet these charges?
Yes, sir.
Mr. Green, do you believe your client is mentally competent?
Yes, Your Honor. She's been able to cooperate with me in every regard.
All right, sir. Ms. Jackson, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes.
Let me tell you why I asked that question, because I'm not trying to suggest that you would not be or should not be satisfied with the attorney's representation. Instead, I asked that question just so you would have an opportunity to let me know if you were not satisfied, if you thought his work was somehow deficient or otherwise legally ineffective. My question would give you the chance to tell me that, and we would work to correct any problems that might exist with the attorney's representation. But I should also tell you, pardon me, that since I give you that opportunity to tell me now if there's any problem with the attorney's representation, that effectively means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. Do you understand that?
Yes, sir.
And understanding that, are you still telling me that you're satisfied with your attorney's representation?
Yes.
There's one other area that I need to discuss with you at this time. That has to do with your decision to enter this plea of guilty. The law says I must be satisfied that it is your decision, freely and voluntarily made or entered into, to enter the plea of guilty. And so I ask you a couple of questions to help me in that regard. First, has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty when you would not otherwise do so?
No, sir.
Pardon. Has anybody paid you anything or given you anything of value just to get you to plead guilty when you yourself would not otherwise do so?
No, sir.
Are you telling me then that you're entering this plea of guilty because the truth is you are guilty and that's the only reason you would plead guilty to such a charge?
Yes, sir.
Those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
We have no objections to it, Your Honor.
Ms. Jackson, let me talk to you about the stipulation of evidence that's been offered by a state's attorney. And in doing so, I'll discuss some other aspects of the law that fit right here, and we'll talk about some other rights that belong to you that sort of surround the stipulation. First, I tell you that the state is required to produce some evidence tending to show your guilt. And that's true even if you're pleading guilty. That's a part of our law, as I understand it, because it helps to ensure that another right that belongs to you, called the right to confront the witnesses, is provided to you. That is your right to have the witnesses brought into court and testify in front of you under oath, so that you can see and hear those witnesses give their testimony, and you can help your attorney cross-examine those witnesses. But this stipulation of evidence says you're giving up that right, and thus you're telling the state they don't have to bring their witnesses into court at all. Did you realize by signing the stipulation of evidence that you were giving up the right to confront and cross-examine the witnesses against you?
Yes.
Also, the stipulation of evidence says you're giving up your right to remain silent, as well as your right to be free from self-incrimination. That's the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself by signing the stipulation of evidence, because it is a judicial confession wherein you admit that all of the material allegations in the indictment are true and that you committed the offense alleged just like it is claimed in the indictment. Did you realize you were doing that when you signed the stipulation of evidence?
Yes.
Did you also understand, because there's another sentence in the stipulation I want to ask you about, that there are court costs in this case totaling $290, and there are reimbursement fees owed to this county in the sum of $75. Did you know that paragraph was in the stipulation also?
Yes.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rests, Your Honor.
Defense rests, Your Honor.
State closes.
We close, Your Honor.
Then, Ms. Jackson, let me talk to you about your plea bargain agreement that we have referenced. I just want to make sure that I understand it the same way you understand it. As I understand the plea agreement, it says that you will enter a plea of guilty to the charge in the indictment as you have done. It says that's going to result in a 5-year sentence to the penitentiary, which will be probated for a period, of 5 years, and that probation will be a deferred adjudication probation. It says that you will be assessed a fine of $1,500 and be ordered to pay court costs in the sum of $290 and reimbursement fees in the sum of $75. The plea agreement also says you are giving up your right to appeal, as I have already discussed with you. And it says you will participate in what we call the TAP program, which is an assessment, and based upon the assessment, a treatment or counseling program for people who have drug or alcohol related problems. Now, that's my understanding of the basic plea bargain agreement in your case. Is that the same as your understanding of the plea bargain agreement?
Yes, sir.
The law says I must discuss with you further what a deferred adjudication probation is, or at least to discuss that there are benefits to such a probation, but there are also detriments. You have a good attorney, and I know he has already discussed I'm sure he has already discussed these with you. But I still, under the law, have to. It has seemed to me in the past that the easiest way to describe what benefit exists for a deferred adjudication probation is to define those terms. So that's what I'll do. Deferred means set off to a later date. So you might ask, what is set off to a later date? The answer is the adjudication, deferred adjudication. So what is the adjudication? The adjudication is the court's decision to find you guilty or not find you guilty. If you are on probation and satisfactorily complete your probation, thus we have deferred adjudication probation, and the finding of guilt that is deferred has never been entered, then you can say legally and factually that you have not been convicted of this charge. That is a benefit to you. But that, of course, requires you to satisfactorily complete the probation. I mentioned there are detriments also. One detriment is that the state can use your deferred adjudication probation and treat it almost as if it were a conviction, and thus deny you of certain privileges, such as licenses to conduct a professional business. For instance, they could deny you the right to become a lawyer, or to be a plumber, or perhaps to be a nurse, or some other profession. That's a detriment to you. It's possible that an employer, especially a private employer, might find out about a deferred adjudication probation, which, by the way, I don't think they should be able to, but they might. And they might deny you employment, or they might deny you promotions within the employment. If they do, I think they're wrong, but nevertheless, that would be a detriment to you, a negative. And then finally, and perhaps the most significant detriment to a deferred adjudication probation is this: if you do not follow all your terms of probation, if you violate the terms of your probation and the state files a motion and gives you notice alleging that you violated the terms of your probation, and after a hearing, if it's determined that that's exactly what happened, that you violated your probation, then the court hearing your case could enter the finding of guilt that has now, or if I follow the agreement, will now be deferred. They could enter that finding of guilt, and they could consider the entire sentencing range of a third-degree felony all the way up to 10 years in the penitentiary. Now, that's a detriment. Do you understand that there are both benefits and detriments to a deferred adjudication probation?
Yes.
Knowing that, do you still want me to approve and follow your plea bargain agreement?
Yes.
All right, I announce that I will accept and follow the plea agreement in this case. And I'm signing the plea agreement to so evidence that. Ms. Jackson, this is cause number 10,756, as I've announced, it's styled the state of Texas versus Winona Rochelle Jackson. Based, Ms. Jackson, on your plea of guilty, based upon the evidence you stipulated to, I find that the evidence is sufficient to find you guilty of the offensive assault of a public servant as alleged in the indictment. But following your plea agreement, I do not enter that finding of guilt at this time, and instead defer that decision to a later date to see how you do on probation. And as I mentioned before, if you successfully follow all the terms of probation, that finding of guilt will never be entered and you will not be convicted. Do you understand that?
Yes, sir.
Pardon?
Yes, sir.
All right. Now then, in following your plea agreement, I also suspend the imposition of any confinement and instead place you on probation for a period of 5 years, provided you follow all the rules of probation. So let me ask you, do you understand what the rules of probation are that you will have to follow?
Yes, sir.
Did you have a chance to discuss them and go over them with your attorney?
Yes, sir.
Can you follow these rules?
Yes.
Will you follow these rules?
Yes.
And I ask it that way because if you cannot or will not follow the rules, then frankly, you're probably wasting your time here today, because if you cannot or will not follow the rules, you're not likely to be allowed to stay on probation. Let me ask you another question about the rules, or related to, and I want this on the record, even though I already know the answer. That question is, are you able to read and write the English language?
Yes.
Then I'm not, since you are able to read and write the English language, I'm not going to read all of the terms of probation to you. Instead, I'm going to cause a copy of the rules to be made for you and to be provided to you when you meet with your probation officer, who, by the way, is present with me here in the courtroom. He will meet with you in his office, which, just geographically speaking, is located just north of Mr. Green's office there on the square. I'm not going to read the rules, as I said, since you're able to, and you can read them anytime and as often as you want to. But I do want to mention some for emphasis to make sure that you understand them and to give you a chance to ask questions about some and to make sure I have some of the information that I will need in these rules. First, emphasis is don't break the law. Not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol in any form. Don't go to places where drugs or alcohol are sold, served, consumed, or possessed. I do make 3 exceptions as to where you can go that has alcohol for sale, like a grocery store, a convenience store, and even a restaurant. But although we make an exception and allow you to go into those places, you cannot purchase, possess, or consume the alcohol in those places. Each month you will report to the probation office, and you will do so here in Scurry County, and do so before the 5th day of each month, unless you and your probation officer schedule another date that works for you. I'm told that you reside at 417 36th Place. I'm told that by the papers that have been placed in front of me, and that's here in Snyder. Is that a correct address for you?
Yes, it is.
You will continue to reside in that address at that location. You will not move to another address unless you get permission from your probation officer. Let me tell you that they will not usually have any problems in giving you permission to move. They just want to know where you're going to be and that you're not going to be in some place that will get you in trouble. The financial obligation that you have on this probation totals $1,865 for the fine, court costs, and reimbursement fees. Are you, I think that there's information provided on these forms saying that you want to pay that obligation out on a monthly basis. Is that correct?
Yes, sir.
And the information given to me says you're requesting permission to pay $40 per month to pay these obligations. Is that right?
Yes, sir.
Do you understand that there is another obligation of $60 per month, which will go towards probation supervision fees?
Yes, sir.
Those two together total $100. Do you have the funds and the income to pay those amounts each month and still take care of your needs and the needs of any dependents you might have?
Yes, sir.
All right, I approve that request and will make that a term and condition of your probation. Ms. Jackson, there is an obligation to observe a curfew while you're on probation. Further, you're not to leave this county for more than 3 days without written permission from your probation officers. You will perform 160 hours of community service restitution. And then you will come back to see me on the 17th day of December for a probation performance review. That's not an adversarial proceeding. We're just checking to see how you're doing on probation. If you are doing everything you're supposed to do, we will say, good, that's what you're supposed to do. If you're not, then we will try to redirect your conduct so that you can and do successfully complete your probation. I have 2 sessions on December 17, one at 9:30 in the morning and one at 1:30 in the afternoon. I will give you your choice of what's best for you. Which one would you choose?
The afternoon.
All right, that'll be 1:30 p.m. on December 17, 2020 for the probation performance review. Now, these are not all of the rules of your probation. There are many others. All of them are important. But since I didn't mention all of them, and since I told you I would give you a chance to ask any questions you might have about the ones I did mention, let me give you that chance. Do you have any questions about any of the rules?
No, sir.
I beg your pardon?
No.
All right. Then those will be the orders of the court. You will supply your thumbprint to Mr. Oliver on the judgment. I'm sorry, your thumbprint already is affixed to the judgment. You will see Mr. Oliver. You will meet with him at 10 o'clock tomorrow morning in his office. As I say, they're on the square just north of Mr. Green's office. Is there anything else before we conclude?
No, sir.
Mr. Green?
No, sir.
Mr. Smith?
No, Your Honor.
Thank you all. Thank you, Mr. Hanshu, for assisting us. And we'll be in recess.
All right. Good seeing you, Pete. Good seeing you, Judge.
Good to see you.
Y'all have a good one.
You bet, Charles.
Ben, I've heard about you. I hadn't met you, but good seeing you too.
Actually, I think we did meet. It's been a many years ago. You were here. I think you might have been at Terry's house, and I was over there for just a little bit for some reason. It's been a long time ago.
Maybe one of the girls' graduations or something.
Could be, yeah.
All
All
right.
right. Thank you all. I'm ending the meeting.
All right.